Are the slide, how do you advance? Oh, is it just going slow? Weird.
Yeah.
Yeah, okay. It may take a little bit of a workaround. So I'm Alex. I am a staff attorney at Legal Action Center. Sally Friedman, she is our Senior Vice President of Legal Advocacy. She's on Zoom. She has been doing privacy at LAC for many, many years. So if there's any questions you have that I can't answer, she can fill in. So she'll also be here. And we have a little system for if she wants to share. So if you have any questions I can't answer, she'll be able to answer. These are just our general slides on LAC. I don't really go over them, but I leave them in the slides if you ever refer to them later and need to know our mission statement, which is also changing, and it's currently, so that may change soon. So I'll send it along once we have it. So the learning objectives for today. First, we're going to identify any relevant privacy standards for substance use disorder and mental health records. It can be a kind of complex area, and it's important to know and always brush up on them every year. We're going to apply our laws to common scenarios. I have a number of case studies. I just think it's the easiest way to learn privacy. A lot of these issues can be sticky. There's also a lot of room for conversation after the case studies. So if there was a question you had or an angle that you were confused about, we can talk about that. We're going to talk about the newly revised CHAMP consent form. I actually have copies of the consent form and a tip sheet on how to update any ones that you all currently have. We will go over those in the presentation. We'll also look at recognizing special confidentiality issues involving minors. A lot of the confidentiality TA requests we have involve minors. So we just added a whole section into this presentation to ensure that people have that information. And also we have places where you can locate additional information or additional resources if you have any other questions about privacy. But of course, LAC is always open for TA if you have a question, no matter how small. Okay, so why does privacy matter? It's really helpful to remember that healthcare privacy is a civil right. Privacy laws are anti-discrimination. They're an anti-discrimination tool. When your information is private, you're able to prevent discrimination in certain settings from having certain information that you don't want to have shared. And that's a civil right. People also get to choose where and when their private health information is shared. So that's really important that every patient gets to decide what information is shared in different settings. Privacy is a very important component of care. It can help patients share openly with their providers. There was recently a study that protecting patient privacy leads to more attention and care. So when patients feel like their providers are actually listening to their privacy needs and protecting their information, it's more likely that they're able to have better health outcomes and keep seeing that provider. Obviously, patients do not like when their healthcare information is shared without their consent. And finally, it's the law. You have to follow these laws for several reasons, including that you're all business associates of CHAMP. We'll talk about that in a bit. But as business associates, you do have to follow HIPAA laws. And then when you receive certain information related to mental health or substance use disorder care, it is protected. So even if you didn't want to, you have to. Okay, here's our first case study. I really liked yesterday how we were all collaborative. So I think we can read it together and then just turn to the people next to you. We'll have a few minutes to talk about it. It's actually funny as a silly word. A lot of these case studies are intentionally tricky. So if you aren't sure, I don't want anybody to feel afraid to say the wrong answer. Even through making these slides, a lot of times Sally and I would look at each other and say, what actually is the answer to this? Or like, how could we make this more sticky? So please, this is open. This is why we're here to learn. Okay, so the first case study, that's Cassidy. Cassidy works as a treatment counselor at an SUD treatment program. One of Cassidy's former clients is a well-known podcast host who discusses drug policy, and Cassidy's husband attended one of the podcast live events. So Cassidy is the one who works at the treatment program. That's his husband, and the husband attended the live event. The podcast host is open about their past substance use and recovery. So they talk about it on the podcast, it's open. Can Cassidy tell his husband that the podcast host was one of his most inspiring clients? So the answer options are A, yes, because the podcast host is no longer a client, he's no longer a patient. B, yes, because Cassidy's husband already knows the podcast host is in recovery and received SUD treatment services. He names the facility on the podcast. He talks about it openly. C, yes, because married couples, the couple are married, can share information confidentially. Or D, no. So what do you all think? You can talk amongst yourselves if anybody wants to share.
I say no, when in doubt, no.
Yeah, I'm hearing a lot of no's. Did anybody think yes?
I'll try and
Okay. Oh yeah. So Ryan Gallagher thinks yes. Let's see what the answer is. So the answer is no. Cassidy cannot reveal that the podcast host was one of his former clients without the podcast host's written consent. When you work in a Part 2 program, it doesn't matter that the podcast host is no longer a client. The podcast host still has the right to determine when that information is shared. And there is no exceptions for married couples or other groups. So no roommates, no parents, no friends. The podcast host privacy rights stay. Privacy means the right to tell your own story. So yeah, the podcast, or sorry, the Cassidy would not be able to like tell any parts of Cassidy's, or sorry, the podcast host story without the podcast host consent. So I really liked the answer when in doubt, no. You must maintain privacy forever, even if you no longer work with them, if the client passes away, if the client is even your friend or family member, it doesn't matter. Also, what's key is even if the recipient of the information already knows the information. In the example of Cassie and his husband, the podcast host was, openly sharing his treatment, saying what facility he went to, giving all the details. That doesn't matter. Even if the person knows, you still cannot share. This can sometimes feel counterintuitive because it's like they already know, why can't I share? But the privacy laws don't take into account who has information and who's receiving it for the first time. It's just that holders of information, no matter what anybody else knows, have to show why you have authority to be sharing this specific information. I think that's a really helpful tool that even if two people know, you have to, as a holder of this information, prove why you have that authority. Okay, privacy landscape. There are multiple privacy laws that apply to different kinds of records, and often more than one law will apply to a given circumstance. The rule is that the law that is the most protective of a patient's privacy will be the one that applies. This can be sometimes a complex area of the law because they're really overlapping. Also, it's a complex area because a lot is changing with technology and different things. So you can always reach out if you have any confusion about which law applies or how to apply it. One thing that was really helpful for me when I was learning privacy laws is they don't work like bumper cars. When you learn in the New York State training, the one after this one, after the break, a lot of the New York State laws bump up against each other. If it's not a self-insured plan, it's a fully insured plan, a different law applies. Privacy is a little bit different. They work like panes of glass that are overlapping each other. So kind of like this image, it's not just mental hygiene law or just 42 CFR Part 2. It would be like how they overlap each other depending on the information. The thing that's important to know is HIPAA is the floor. I didn't know this, but HIPAA usually has the weakest protections, and all of the other laws are more protective over that. But so the strictest privacy law for certain information will always be the one that applies to that specific record. Privacy laws protect certain information in certain settings. So sometimes these laws don't apply to all information. That can sometimes be confusing, but certain information and when it's being shared in certain circumstances is why it's important to know the complexities of these laws. Okay, so here's our chart with all of our privacy laws. Well, not all of them, but the ones that we'd be using the most commonly. So the HIPAA privacy rule, I said that that's the floor. It's usually the least protective. It applies to all general health information. They do have heightened protections for psychotherapy notes. So if that did come up, you can reach out to us if you had questions about that. But all protected information under HIPAA are individually identifying information relating to someone's past, present, or future healthcare. Who must follow this? Covered entities, which are most healthcare providers, and business associates and their subcontractors. Through CHAMP, we are all business associates, so we all do have to follow HIPAA. As business associates, we do have business associate agreements that discuss what your rules are under HIPAA. So if you did have any questions, you could turn to that business associate agreement. The other law that we talk about a lot is Article 27F. This protects any information relating to an individual's HIV test, diagnosis, treatment, or their contacts. Who must follow this? Health and social service providers in New York, and anyone who receives confidential HIV information from a health and social service provider. So if you do have a client with HIV, you receive their information from somebody who is bound by Article 27F, you would also have to follow these rules. 42 CFR Part 2, that will be the bulk of this training. What is protected? So this protects information that identifies an individual as seeking or receiving SUD treatment of a Part 2 program. So not just when they're actually in the program, but also when they're seeking care. Who must follow this law? Part 2 programs. This does not include all healthcare providers or all SUD treatment programs. A Part 2 program is a specific kind of SUD treatment program, so only a Part 2 program would have to follow this, but also lawful holders. We'll discuss what it means to be a lawful holder, but if you're not a Part 2 program, but you still receive Part 2 records, you would have to be bound by 42 CFR Part 2. And finally, the mental hygiene law. This protects mental health clinical information that relate to a patient's identity, diagnosis, prognosis, treatment, and care coordination. And who must follow this? Mental health facilities that are operated, licensed, or funded by OMH, and anyone who receives these confidential records from a covered facility. So yeah, those are pretty much the laws that we're working under. The main takeaway that I would take from this is that when you're following the law, if you receive any of this information, you also have to follow the laws, even if you're not one of those types of facilities. Okay, key terms and concepts. So I'm gonna go one by one. They can kind of get in the weedsy, so I'm not gonna go as in depth, but if you had questions, let me know. So in general, the words that you'll see a lot are use and disclose. Use means any use or sharing of protected health information within an entity. So that's I work at LAC and I'm using somebody's records with somebody else at LAC. Disclose means sharing that protected health information outside of that entity. So that's I'm filing an appeal and I'm sending information to an insurance company for that appeal. Disclosure could be describing a patient in any identifying way. This could be sharing via email, text, or form, and it's not limited to the actual medical records. So in the example of Cassidy and his husband, that would be sharing protected health information. If I said, oh, Ryan, I have a client who has this name and is getting this treatment, that is also sharing protected health information. It's not just the actual medical record. There's something called the minimum necessary standard. This is the law. It's basically that when you are sharing protected health information, you should only be sharing the minimum necessary information to achieve the purpose of the disclosure. I only recently started taking clients with Champ, and I was having a call with Geneva about a client, and I was asking her a question. I said, oh, he sent me this document. Let me email it to you. And she said, wait, stop. I don't think you need to send me the email with the document. That's not minimum necessary. You could just summarize it for me. And it was a really interesting, fact pattern in real life that I wasn't doing the minimum necessary standard. And sometimes it's easier to just, oh, let me just send over this document. Let me just share this information. But that wasn't protecting that patient's privacy because I didn't have his consent to share it. And also, Geneva did not need to see the whole document for me to say generally what was in the document. So there is no reason often to share the full medical record or an entire treatment plan if they just need bulleted information. It can be really helpful to just like bullet out the information yourself and kind of not over disclose because it's really hard. Once information is shared, it's hard to contain it and it's better to keep it as private as possible. Okay, so HIPAA. So what is it covered? Oh wait, one thing I wanted to note too is throughout this training, I'll use the phrase authorization. Authorization in this context doesn't always mean it doesn't mean authorization for treatment or authorizing care. It's an authorization, it's a consent to share information. It's not the consent to treat or, so that's just an important distinction. And yes, okay, so HIPAA. What is a covered entity? A covered entity is a health plan, a healthcare provider, the entity that is actually covered by HIPAA that's getting the protected health information. Business associate. So this is where we come in as CHAMP. For HIPAA purposes, a business associate is a person or an entity that performs functions or activities on behalf of a covered entity, requiring access to protected health information. This is why when we receive information, we are covered by HIPAA. We're business associates. That's different than if like a friend gave me their medical records. I'm not covered by HIPAA because that's just my friend giving me records, whereas we're associates of a business. An authorization, as I just said, it's a formal signed document that gives healthcare providers permission to share protected health information for purposes that are not otherwise allowed by law. There are some exceptions to this. If you think something falls under exception, reach out. But typically, you need a formal signed document. This ensures compliance with federal privacy laws and can define exactly who can receive the information, what's shared, and for how long that information can be shared. And protected health information is any information which includes demographic data that relate to an individual's physical or mental health. So I also, it should be It must be identifying the individual or providing a reasonable basis to do so in any form. So that is electronic, paper, or oral. So as I gave that example earlier, if I were to say, this is my client's name, this is what their situation is, if you can identify them from the info I'm sharing, that is protected health information. Under 42 CFR Part 2. So as I said, not all SUD treatment facilities are Part 2 programs. It's a legally defined entity under federal law. Whether something is a Part 2 program or not, they hold themselves out as providing substance use disorder diagnosis, treatment, or referral for treatment, and they're federally assisted. If you ever aren't sure if something is a Part 2 program of records you're receiving, you can reach out about that as well. And most notably, a lawful holder. So even if you are not a Part 2 facility, if you receive documents from a Part 2 facility, you are considered a lawful holder of that information. That is an individual or an organization that receives patient identifying substance use disorder records from a Part 2 program or from another lawful holder. So if you get the records from a social worker and that social worker got them from a Part 2 record, you are still bound by 42 CFR Part 2. You either need written consent or you have to follow under one of the exceptions to written consent. Those are like medical emergencies, court orders, if there's an audit. So those usually won't come up, but so typically you will need this consent. And patient identifying information under 42 CFR Part 2 is similar to HIPAA, just patient identifying information. So handling protected health information under HIPAA. So we're all business associates. You have a business associate agreement, which discusses your HIPAA responsibilities to your clients. There is a HIPAA security and breach notification rules section. If you are hacked or something happens and compromises your data, there are certain steps that you have to take, and you do have to notify the patients who may have had compromised data that their information has been disclosed in a way that was not privy to their consent. This can also apply if you send information to the wrong email address. So if that does happen, I keep saying this, but please reach out to us about next steps, but just be very aware that there are certain security measures that you may have to take if data is breached. Okay, consent. So disclosures are permitted once a patient has given their written consent. You need written patient consent to obtain and to share protected health information. Each law has specific criteria on what is required for an authorization. And this, you can also make sure that all of these laws are being followed on one form. The form on this slide, DOH 5032, is an example of a form that complies with all privacy laws. I don't have the whole form there, but that is a good example of, you want to just make sure that everything is captured in one form, but that is an option going forward if you'd like. Oh, sorry, I do something. So we're actually going to go through, there were new privacy laws and new forms. I have both the forms, and Carla made a very helpful tip sheet for updating your current consents. We're going to go through them together, so I'll just pass these out, and then I'd love if we read them together. So I'll take them in threes. Yeah, I'll just go with 3. There's way more than I printed out. Way too many. Here's some tip sheets as well. Let's try them. Peace. Of course. So we can go through anything, but first I wanted to ask, did anybody have specific questions with consents when filling them out? Do you find yourself getting tripped up at any sections? Are you asking any questions?
I have a question or a comment.
Yeah.
During COVID, we did verbal consents. So I was just curious about that, those verbal consents and when they would expire, or
Yeah.
if you could just speak to a verbal consent.
Yeah, so you can't do verbal consents. I will say, and I'll talk about this later on, there is a lot of flexibility about what written consent means. That doesn't mean wet signature. So there can be other options. At LAC, we use DocuSign, and people can sign on their phone. They don't need a computer, which is really helpful. I know that CSS uses Adobe. You can easily sign that way. You can also send a consent in the mail, have someone sign it, and then send you an iPhone photo back. But yeah, there's a flexibility on what written means. In my last job in Boston, we had a client who had a physical disability, and we were just like we didn't know he had a that accessibility tool where you can like blink and your eyes can sign something, and we were able to have that be a signature option. I mean, that was in a different state, but yeah, so there can be flexibility, but yeah, there should be a lot of options if you did have a client, but yeah, verbal signature and verbal consent isn't admissible, unfortunately. Okay, so this is the new form. So we can go one by one. You put the patient's name on the top. We do have this version. This is the template. When I send these slides, you can click right here so you don't have to type it all out yourself. You can just put your own letterhead on top of it. So you can just take this and just go with it. But in case you wanted to make your own, I authorize the following people and entities. So you could put in the names of all of the entities. This is really helpful so that you don't have to get new consents for each thing. So if I needed to speak to CSS and I also needed to speak to their health insurance and I also needed to speak to their mental health provider, it could all be on one consent so you don't have to keep signing them for clients. The next blank would be to communicate with and disclose to one another for the following information. Here's where you would describe what's being used. Sometimes if it's more vague, now that I've started case handling, you don't always know what the case is going to look like. If you don't want to have to keep updating that section, you could say to resolve insurance issue or something more vague and broad. This is where the changes are. So SUD counseling notes. If you have SUD counseling notes, and also if you are doing any type of legal proceeding, which includes an appeal, you need a completely separate consent. So let's say I'm helping a client, I'm helping them get insurance coverage for something. Throughout that, we learned that his care was also denied. If I had this consent when I was originally helping him for insurance, and then we're also doing an appeal, I have to sign a whole new consent form. So also for SUD counseling notes, if I need those released, I need a separate form for SUD counseling notes. So I would just maybe always have like a little sticky as you have, yeah.
You might be getting to this, but I was just gonna ask if you could explain what SUD counseling notes are, probably going here. And also just to flag that you need separate forms, but it can just be like this form twice.
Yes.
Like one for the counseling notes, twice for the.
Yeah, that's a great point, Carla. So if you do think that it doesn't have to be like a completely separate form. It would just be the same form, but that box checked, or the same form, but just for the purpose of the appeal as a separate document. So SUD counseling notes, these are clinician records that document private therapy sessions. That's why they have heightened protection. So if there is something, it's basically like the provider's actual notes of the person's treatment in their therapy sessions. Is there anything more specific that you wanted me to share about?
No, I know there's like a specific definition in the law. I will say, like at CSS at least, we don't often handle that level. Like you aren't usually getting therapy notes. I don't know how many are. So this, doesn't come up for us much. I just wanted to,
Yeah.
clarify for folks.
No, please, that's helpful. It looks like the legal definition includes that the SUD clinician's notes analyzing the conversations in the sessions. So it's not just this person came to me and has such and such diagnosis, it's the clinician's notes actually going through their thoughts on what the person is experiencing, which is why they're heightened. Yeah, if you do think that you have a case, I don't think that I've never had a case where I've dealt with SUD counseling notes. If it does come up, you can ask us, but just a good practice to get the consent, always a good practice.
Alice, I have something to add. Can you hear me?
Yes, please.
Yeah.
Do I mute myself?
I just wanted, no, I muted myself instead of lowering my hand, sorry. I wanted to just add though, is that they have to be segregated from the rest of the record in order to be considered SUD counseling notes. And a lot of places don't have the technology to do that. So don't assume if you're getting, let's say, a client's entire record that includes their case notes, don't just assume they're SUD counseling notes. You would really need to verify that they were segregated from the rest of the record, which is going to be kind of unusual. So I think it's rare that something would technically meet the definition of SUD counseling notes, but we can help you figure that out.
I can repeat that to everybody. So SUD counseling notes have to be segregated from the record. So if you request somebody's health records and you think that there may be SUD counseling notes, it's often that they're not. So basically just don't assume that something is an SUD counseling note, and you can always double check. A lot of providers don't have the technology to segregate them as they should, or maybe just don't. So yeah, they would have to be segregated. So yeah, thank you, Sally. Okay, so then I authorize uses and disclosures for the following purposes only. This is where you put the purposes of your representation. Unless I revoke my consent, this consent will take effect immediately and expire. You can put the date that it expires. On most of my consents, I've been putting at the close of representation, or like at the resolution of the issue, just so that if you do have a client for more than a year or something, you don't have to send a new form. Next, it says, I have the right to revoke this consent in writing at any time, except to the extent that action has been taken in reliance upon it, which means if you're already taking action, let's say I filed the appeal, it's submitted, my client can't then probably revoke consent because it's already been filed, but I understand that I may revoke consent by. I think this is really helpful to talk to your clients about how they can revoke consent with you. I think that going through this document completely with clients is really helpful, and already having together an understanding and an agreement of what revocation would look like. So basically, I'll email you and say I want to revoke consent, and I'll say the specific line, or I'll text you, however you communicate with that client. The next sentence says, I understand that my substance use disorder treatment records are protected under federal law, including 42 CFR Part 2 and HIPAA and any applicable state laws. My treatment records can only be used or disclosed with my written consent, except as permitted by all those laws. I understand I have the right not to sign this consent form. And then there's a statement that I have been offered a copy of this form that has been explained to me in a language I understand. I acknowledge that there is a potential for the records used or disclosed pursuant to the consent and to be subject to redisclosure by the recipient. Then they can sign the document. Really notable. This line at the bottom, the 42 CFR Part 2 prohibits unauthorized use or disclosure of these records. This statement has to now be on 42 CFR Part 2 records. There is an option that you can have like a more detailed document in addition to it. I think it's easier to just have this one sentence, but that is something that you'll want to include on your 42 CFR Part 2 consents going forward. So we do have a tip sheet, which also just has, I pass this around too. Everything included on that template is there, but just in case you wanted to make your own or just have this for your own records, the tip sheet says that there are two kinds of disclosures for which you now have a separate consent form, which is the SUD counseling notes, and if anything is being used in a legal or administrative proceeding, that the consent form must now include instructions on how a client can revoke their consent, and then finally sending a copy of the consent form to whoever you are making disclosure to. So I have a client, we sign this form together. If I now want to get that information, I have to send that consent as well. So the form should kind of follow the information that you have. So that's the updates. Did anybody have any questions about those?
I have a question.
Oh, yes.
Yeah, thank you so much for this. Very interesting. I just wanted to confirm something, like opening up a case in Salesforce, for instance. I mean, because I'm doing it for so long, do we need a consent for that now?
No, to open up a case in Salesforce, no. But if you do, if you have protected information, there's a little box when you click case notes that you can
Oh,
say that it's protected information.
okay. Yeah, I remember that. But yeah,
Yeah.
I've never had to use a consent before for Salesforce. But I know anything in depth, like if I was doing a story on somebody and this and that and putting that pertinent information, I would definitely get that. Yeah, I just wanted to confirm that to make sure I was on the right track thinking.
Of course, Geneva's like our Salesforce maven. I don't know if Geneva, there was anything else you wanted to say about Salesforce and these
Well, I
kind of
just wanted to
records.
flag that confidentiality box is only if it's part two information. So that's only if it came from a part two provider.
Oh,
You had to
yeah.
like get consent. So it's not like every time you have to be like, this is confidential. No, the business associate agreement that Alex was talking about earlier covers, um, everything that goes into Salesforce.
Okay.
Thank you
Thank
so
you
much
so
for
Yes.
asking
much.
that.
Appreciate that.
I'm just gonna repeat
So
back.
can
So for
I
everybody
actually
who,
go back to something that
please, yeah.
happened earlier? And I just want to confirm. So the actual definition of a substance use disorder note is that it is separate from the medical record,
So
or
let me pull up the legal definition right now.
it's just like programs might not actually be complying with this rule because they're not separating the notes that actually should be separated. No.
That may be a Sally question.
Yeah.
The legal definition of SUD counseling note is notes recorded by a professional which analyze or document conversations from private, group, joint, or family SUD counseling sessions. These notes must be separated from the rest of the patient's record and are subject to enhanced privacy protections. So Sally, is it that if providers don't separate it, are they violating the law, or do they just, yeah?
No, it's just that it wouldn't constitute a SUD counseling note. That's all.
Okay.
And
So
so
it's like
therefore you,
psychotherapy notes where it's like someone's own private impressions that is not going into the rest of the medical record.
it's very, the definition is very similar to the
Okay.
HIPAA definition of psychotherapy notes, but there's nothing that says you must do this. It's just that if your notes are this kind of note and they're segregated, then consent to disclose them has to be on a separate consent.
Did everybody hear that?
Yeah.
Okay, great. Yay. Great. Yay.
Alex, I'm sorry, I have one quick question too.
Of course, yes.
Just about the form, a technical thing you mentioned. So you said
Yeah.
instead of a date that it's valid to, you could actually write the words, until the end of until the issue is resolved or something like that to indicate rather than an actual end date.
Yes.
Okay.
So under the unless I revoke my consent, you can say upon the conclusion of my champ case or upon the
Okay.
conclusion of, yeah, you don't need a
Okay,
date.
thank you. Great,
Yeah, of
thanks.
course. Yeah, of course. Okay, so identifying when part two applies to you, it's quite easy for us. It's this flow chart. So first you ask yourself, are you working at a part two program? If you are, then yes, 42 CFR part two does apply to you. If you do not work at if you don't work at part two program, you would ask yourself, did I receive this part two information pursuant to patient consent? So did I get a patient's signature from their part two program? I was able to get their documentation. If the answer is yes, part two applies. If you didn't, if they just told you I went to this part two program, if they self-disclosed, then part two does not apply. Yes, I was gonna make another point, but I think, yes. Oh, the information or the protection for part two follows the information. It doesn't follow what facility you're in. So if the information came from a part two program, that part two consent will be needed throughout the lifetime of that information being shared. Okay, another case study, Ricky. So Ricky calls Champ for help getting her substance use disorder treatment covered by her insurance. Ricky shares information about her substance use and recent diagnosis and emails a copy of her treatment plan from a part two program. Is any of this information protected by part two? So here are options. A, yes, all of the information is protected because it relates to Ricky's substance use disorder diagnosis and treatment. B, none of this information is protected by part two. C, only the information about Ricky's diagnosis and treatment is protected. Or D, only the email with the copy of her treatment plan from a part two program is protected. So does everyone think?
A.
Do other people? Do you want to say why you think A?
I just think I think it's all protected because it was part two program.
Okay. We have one vote for A. Does anybody else have one? Yeah.
I think it's A, because even though Ricky's not signing the consent, it's still information that should be protected by part two. So when you're receiving it, you still have to maintain part two privacy.
Okay. Yeah.
I think it's B because only the treatment plan actually originated from the part two protected program. I think like because she's verbally sharing the information, the verbally sharing, she's what it volunteered.
Any other
I agree with
thoughts?
that.
Okay. It's actually B. I know, scary. So none of this information is actually protected by part two. Before I share this, I do want to say the information is still protected by HIPAA because you are business associates and you have the business associates agreement. So it doesn't mean that it's like free if it's not protected by part two. But CHAMP is not a part two program. CHAMP received this information, including the records, directly from Ricky. Part two does not apply to self-disclosure. So Ricky disclosed all of this information herself. She shared the records. It's not protected by part two. Champ would only become a lawful holder and be under under the Part 2 umbrella if it received those records pursuant to Ricky's written consent. So if Ricky was a client of Champ, she signed a release, a Part 2 release, a Part 2 consent, sorry, and we got that document from the Part 2 facility itself, then it would be protected information, but it was a self-disclosure. Yeah.
If one of our CBOs is a Part 2 program.
Yeah.
That change it?
Yeah, so if you are a Part 2 program, that goes back to our flow chart. If you're a Part 2 program and you received the information via self-disclosure, that as a Part 2 program, you're a holder of the information, and so then it would apply to you. But if you're not a Part 2 program, this is when it came back. Yeah, so then you know what? You were right. You ended up being right. If you're a Part 2 program, yes, this would apply to you. Okay, so the general rule for Part 2 records. If you want information from a Part 2 program, you need a Part 2 consent for them to share with you. Champ is not a Part 2 program as an entity, but individually, you all may be Part 2 programs. If you're not a Part 2 program, you're still covered by HIPAA and some of those other privacy laws. If you are a Part 2 program, you'd be covered by everything we just discussed. Yes?
All right.
No, of course.
Tangential question. That case study.
Yeah.
If the like treatment plan is shared by basically anyone else other than the client, you just have to assume that it's coming through like a Part 2.
That's a really great question. Yeah, so like if I was talking to like a social worker, they sent me the treatment plan and it's from a Part 2 program, I would hope that everybody is following 42 CFR Part 2. If I received information and it wasn't from the client, I would assume that I'm covered by Part 2. I don't think you have to go back and ask them how they received the information because the protection follows the information. So even if like somebody had breached their obligations, doesn't mean that it can keep being breached, and I would still take the precautions. But that's a really good question. Hopefully with these new updates, when they are you saying that if Ricky got them, so if I see what you're saying. Hopefully, the other party that was sending that information would be sending you their consent. That's why you now have to send the consent when you send the information for Part 2 released information. So hopefully that person would say, here's my consent to release this Part 2 information. Here's her treatment plan. And I would know it's protected by Part 2. If you do receive Part 2 information without that consent, I would still move forward getting that consent and only redisclosing it if I had 42 CFR Part 2 consent. Yeah, of course. So even though most Champ partners are not Part 2 programs, they will become lawful holders. So you still want to follow these rules. And that means that you need consent to redisclose information. So the example Laura gave, even if I wasn't a Part 2 program, if I did receive Part 2 information, I should get a consent so that I do not redisclose. There were updates this year to consents for treatment, payment, and healthcare operations. We have lots of emails back and forth with CSS. We don't think this is going to come up for you all. We did just want to flag that there, is a change for this if you do see it. We don't expect that this would come up, and we didn't want to overcomplicate things. If you do think that you've received any documents in this way or have to disclose under the TPO exception, let us know. But we don't expect it'll come up. I just wanted to let you know in case you hear of it. Okay, another case study, Mallory. So Mallory signs a consent form authorizing her Part 2 program to share treatment records with Champ to assist in an appeal with her insurance company. Champ submits a copy of the treatment plan in the appeal to the insurance company. Is patient consent required? Why or why not? So A, yes, patient consent is required because Champ received the records with Mallory's consent. Champ is a lawful holder of Part 2 records. B, yes, because patient consent is always required when disclosing any SUD-related information. C, no, because the insurance company already knows that Mallory was in treatment at the Part 2 program. Or D, no, because Champ is not covered by Part 2. Can we have a vote for A? B? Yeah. Okay, a lot of people are saying B. So it is A. Yes, I know we need the mug again, whoever gets the most right questions. So yes, patient consent is required because CHAMP is a lawful holder. The information was received pursuant to Mallory's consent with their Part 2 program. It does not matter that the insurance company already knew that Mallory was in treatment. The consent is still needed. Also wanted to note here, HIPAA would always be required for the protected health information. Just a Part 2 consent would not be required for this fact pattern. So you still would need HIPAA. This is just about Part 2 records. Did anybody have any questions about this? Oh, and I also wanted to note too, as I noted originally when I shared the consent form, you would need consent for disclosures for legal proceedings, including insurance appeals. They cannot be combined with the consent for another purpose. So if you were filing or submitting this appeal, you would need a separate consent that notes that you're doing an appeal. Did anybody have any questions about this one? Okay. So another case study, West and Amanda, CHAMP Advocate West. Yep, I knew I'd get some giggles. CHAMP Advocate West is assisting Amanda with an appeal after her insurance company denied coverage for opioid use disorder services. West needed to communicate with the Part 2 program Amanda attended and got a Part 2 consent signed by Amanda. The consent had the following statement at the bottom of the form. 42 CFR Part 2 prohibits unauthorized use or disclosure of these records. West signed the Part 2 consent to West sent the signed Part 2 consent to Amanda's insurance company when he submitted the appeal. Did West need to send Amanda's health plan any other notices when sharing her Part 2 records? So A, no, because the consent form West sent to the health plan contains the notice accompanying disclosure. B, no, because the health plan already knows Amanda was in treatment at the Part 2 program. C, yes. West also needs to send the Part 2 notice accompanying disclosure separately when sending Amanda's consent form.
And for the answer, when in doubt, yes.
When in doubt, yes. Yeah.
I think no, because that clause, that phrase is the workaround to having to set the entire notice. Oh, so sorry, I have just left.
So that form, the notice of complete disclosure is this. The 42 CFR Part 2 prohibits unauthorized use or disclosure of these records. Two people like Laura?
I just think, yes, it's an appeal.
Yeah.
You know, that it needs a separate. So that's nice.
Okay, so the answer is no. Nothing else is needed because the Part 2 consent from West, consent form West submitted contained the notice accompanying disclosure. That was a great thought, yes, but he did submit the new consent with the appeal. But you are right. If he was submitting the appeal, he would need a separate form no matter what. So starting in 2026, lawful holders of protected health information who received it from Part 2 programs must include both the signed consent form and this notice. In the form I shared with you all, this notice is just a sentence down here. You can just include it there. You can also have a more like lengthy, spelled out multiple pages. I don't think anybody needs that, but it can be longer form or it can be short form, but it does need to be included in the form. I'm sorry, in the consent form. So practice tips. Here is where it would be helpful sometimes to have the original consent authorizing disclosure to CHAMP for multiple types of disclosures. As we've already said, we're saying it again and again, but if there is an appeal or any legal proceeding, you would need a separate consent. But if you do find that you're going to have to speak to a provider in an insurance company, one consent form can disclose that information to all those places, so you wouldn't always need separate consents. And then when sharing records, you will need the copy of the consent form and also the Part 2 notice, so that little form. So no matter who I'm speaking with, if I'm sharing Part 2 protected information, if I'm emailing a provider, if I'm emailing an insurance company, I will include this signed consent form so that it follows the information. The mental hygiene law also follows records. They don't have a notice requirement, but it may be good to just in their general notice also have the same sentence if you are revealing information that could be protected by the mental hygiene law. Yeah, so those are the practice tips. Okay, so we have another case study. This is Calvin. CHAMP client Calvin and CHAMP advocate Ivan call an insurer to obtain a list of in-network substance use disorder outpatient facilities. During the call, Calvin asked questions and shared some information about his past substance use and recent opioid use disorder diagnosis. Ivan does not share anything, so the champ advocate does not share anything. The insurer asks some follow-up questions and shares information about in-network facilities. Is patient consent required for this conversation? Why or why not? So A, yes, because insurance companies must follow Part 2, and Calvin shared information about his substance use and opioid use disorder diagnosis. B, yes, because champ advocates always need patient consent when joining a champ client call with any third party. C, no, because Ivan did not disclose Part 2 protected information. D, no, because champ advocate Ivan didn't speak. Or E, both C and D. Okay, we were also excited about that. Yay! Yes, no, patient consent is not required for this conversation because no Part 2 protected information was shared. And Part 2 does not apply to self-disclosures. In this call, Calvin was speaking, Ivan was not speaking. Client was just sharing about themselves. Even if Ivan had spoken, we changed this answer because we thought that speaking was important. The conversation would not have involved protected Part 2 information. Of course, if Ivan was saying things about a past Part 2 treatment that Calvin had and was saying it on the phone, then there would need to be consent. So if Ivan had said something like, "Oh yeah, in your last program, you really liked group therapy," that you couldn't share that. But the conversation here did not involve Part 2 information. So I would just, be careful if you are on the phone. In this kind of scenario, you don't need a release, but think about the information you do know that's from Part 2 treatment, and you wouldn't share that. Okay, our next case study. Paige and Sierra. So Paige and champ advocate Sierra call an outpatient substance use disorder treatment program to ask about available services. The SUD treatment program shares information about their available services and asks some follow-up questions. At the end of the call, the program and Paige schedule an intake appointment. Did Paige become a patient of the SUD treatment program at any point during this call? A, no, because Paige hasn't gone for a first appointment yet. B, no, because services must be in person for the caller. Oh, that's a typo. In person for the caller to become a patient. C, yes, because Paige applied for services by calling to schedule an appointment. What do you think?
See, cover seeking.
Yes, exactly. So Part 2 protects the confidentiality of applicants to treatment programs and also protects patients. So once Paige began applying to the program for services over the phone, she became a patient and wasn't just an interested caller asking about treatment. Okay, so with that same fact pattern, does the champ advocate Sierra need Paige's written consent for the call with the SUD treatment program? So when they called together, is written consent needed? A, yes, because champ always needs patient consent for calls with Part 2 programs. B, no, because Paige did most of the talking during the conversation with the SUD treatment program. Or C, it depends. Consent would only be necessary if the champ advocate redisclosed back to the SUD program anything the program said about Paige or shared information from Paige's previous treatment records.
See.
Yes, it depends. So Part 2 protects the confidentiality of applicants, but it's not clear when someone is just asking a question about a program versus when they become an actual patient. Part 2 applies to people who are seeking too. So there's no clear cutoff, so it's always, best to get consent with the patient if you are speaking to somebody you think they may be an applicant. There is no consent required if the call is just an information session. So if you're just calling together to see what services they have, but consent would be required if you wanted to discuss past Part 2 treatment or if you were redisclosing any information that was shared during the phone call. This is interesting. So if you're on the call and the Part 2 program says, who's the patient here? Is it Paige or Sierra? Paige's patient. If the Part 2 program says, oh, great, Paige, I know that you love group programs from what you just shared with me. We'll definitely sign you up for group programs. You can, as a champ advocate, repeat back, great, I know that Paige is really excited for group programs. Because even though it seems innocuous and everyone on the call knows, that is information that you received from a Part 2 program. The person on the call said that to you, and you repeating it back would be revealing Part 2 information. So it kind of gets in the weeds. I do think, it may just be best to always have it signed, just that you have that release. But I think either not speaking or being very careful about what you're going to say is important. And consent for disclosures of part two must be written. So there's no implicit consent, there's no verbal disclosures. If your patient says, oh, I don't care, you can be on the call, you can say whatever, that's not how it works. You still need that written consent. Okay, so we had a discussion section. I know that I think I'm a little bit behind time, but did you all have any questions about requesting, receiving, or sharing confidential data? Some solutions that you've tried for signatures? I know you were asking about verbal signatures. Have you found any workarounds if people previously wanted a verbal consent and needed to sign it?
Well, because so many people have transportation issues.
Yeah.
And we do, phone sessions many times.
Mhm.
We do mail,
Yeah.
consents to our clients,
Makes sense.
or ask them to sign them when they come in, but, have them ASAP.
Yeah.
Could a text message or email, so like if you sent somebody a consent form and they then send you a text message back saying that they've read the consent form that was sent, but maybe DocuSign or Adobe or something is not working, could that like a screenshot of a text message?
That's such a great question. I will say if they are able to text you, they can sign it and then send you a picture of it. What if somebody doesn't have a smartphone?
We don't allow any of that because text is not encrypted. So
Oh, interesting, yeah.
We do not allow any texting communications with
No.
provider.
Yeah, that makes sense. Sally, do you know, have we ever seen that? Can somebody like text back that they've read the form and they consent? Is that verbal? I mean, is that consent?
I don't think so. I mean, as a practical matter, no one's going to complain about it, but it's not technically compliant, no.
Yeah. People can fax. Have you run into this a lot where people don't have smartphones, or it's just
I'm just kind of like a
hypothetical?
like
I will say that with CellJ, the majority of our population are low income. I have clients who don't have internet access.
Yeah.
Their access to a 205 don't have data plans that can carriers.
Yeah.
So sometimes it just
Yeah.
depends on.
Well, those clients, do you send them it in the mail and then wait for them to send it back, or what have you
It
done?
depends on if they feel comfortable having it sent to their phone.
Yeah.
Or their phones.
Right.
That's another, like, we are housing a lot of them at the same.
Right.
So.
One thing that in prepping for this presentation, I watched all the old privacy presentations from our privacy experts. And one thing that came up is when people are in inpatient or residential facilities, CSS will often call the facility and say, I know you can't tell me if somebody's a patient here. I'm faxing you a release. If they're there, can you send it and send it back to me? And that's worked. If people are using libraries, I wonder if you could go to the library and say, hey, we do need these consent forms assigned. I know that you have this capacity. Can we just have like a system where if somebody comes in, they can quickly like use your fax machine or like figure out how to scan it here. So that way they can have access to technology, like maybe having a sort of like relationship with a local library or something. If you find that that comes up, we can ask Jackie, our privacy expert, all of the unique ways that people have been able to fulfill the signatures and see if there's something that could work. If you find that that's a persistent problem with your populations, I'd love to come up with some like best practices in that situation.
Sorry.
Yeah,
of
course.
Oh
yeah. You can go ahead, Geneva.
Thank you. Okay, so I was wondering, you're saying no verbal consent for just HIPAA and part two, or like just for like I know part two is always written, so I just want to confirm that you're saying for any consent, it must be written.
Yes.
Okay.
Yeah. But written is flexible, and I don't know what all those flexibilities are. So you can ask questions, or maybe we can like as a follow-up in the next champ meeting, we can talk about what some of those flexibilities are. Yeah.
It's like the thought behind the non-verbal consent, like not being allowed, it's because you can't like then share that with other people. Right? Like,
Yeah.
like,
exactly, because if you need the form to follow the information, if somebody just says, yeah, you can share my information, I can't like voice record them yet. I mean, maybe in the future we'll have polygraphs and people can verbally consent that way. But until Sam Walton figures that out, unfortunately, we do need written signatures.
But it
It's also
follows
to make
part two. Sorry.
Oh, sorry, say that again, Geneva.
Doesn't it only follow part two, not HIPAA?
Oh, yes, the signature. Yeah. Oh, the form. Yeah, you would only have to use that form to redisclose. Yeah.
Oh,
For
okay.
HIPAA protected information, you don't need to send the form when you're redisclosing that.
Okay.
You can.
The requirement for written is to make sure it really happens. I mean, we've had situations where the client's like, I didn't consent, so if it's verbal, you can imagine people not having the shared understanding of whether consent was provided.
Exactly. Okay. Yes, I would love to keep talking about unique ways to sign. So let's sidecar that and we can talk about that in future meetings. I just wanted to go over quickly special considerations for minors. This comes up in TA requests a lot. These can get misunderstood quite easily, and there's a lot of questions about this. So minors have privacy rights over their own treatment. In New York State, minors are often allowed to make their own healthcare decisions. And if a minor consented to their own treatment, they get to make the decision about how their treatment is shared, where it is shared. Basically, they hold the key to the lock that is their health privacy. So it's important to remember. Special considerations for Part 2 records, even if the minor didn't consent to the treatment, they always need to sign the form authorizing disclosure. So even to share the information with their parent. So if a minor's parent consented to their treatment and the information needs to be disclosed and you need to talk to their parent, the minor still needs to sign the form. Yes, you would still need the minor signature. This can sometimes be controversial, but it's basically to ensure that minors have access to their confidential health care. And it's a key to being able to keep them in care that they need. Sometimes they don't want things shared back with their parents, even when their parent consented to the treatment on their behalf. And be very clear when speaking to a minor's parents what can actually be disclosed to them. A lot of times parents think that they deserve all information, and that's not always how it works. So just always be very clear and look at the consent and what the minor has authorized you to speak back to their parents. On a HIPAA form, if a minor consented to treatment, they would need to sign HIPAA, but if the parent consented to treatment, you could still get the records without a minor signature. So this is more for Part 2 records. If it's HIPAA, parents, if they consented to treatment, sometimes that can be released still. But yeah, a minor would always need to sign. So just some privacy tips for email. It can be really easy to breach someone's privacy via email. In my example earlier, I almost did this with Geneva. Always double check to make sure you have the authority to send this information to the recipient. Double check, double check, double check. Also double check that the email address is correct. I've received emails that were not for me all the time with a name like Alex. People just type an A and it comes up. You can also always send a test email if something's encrypted. I've done this with clients before, just sending a test email, making sure they got it before I'm sending any more protected information. And as I mentioned earlier, as business associates, there is a procedure you would have to follow if there was a breach. So if you accidentally did send protected information to the wrong email address or breach in any other way, you can reach out to us on what you should do if you should accidentally breach, but just know that it's not just oh no, I'll pretend that didn't happen. There are certain steps you have to take. Okay, now we have a question section. I know that we're a little bit out of time. I think I'll finish up the presentation, then we can see. Our key points are that privacy is a civil right. It's a component of healthcare. The strictest privacy protection for substance use disorder and mental health treatments will apply when you're receiving or sharing protected information. Lawful holders will need a patient consent before redisclosing, even if you're not a Part 2 program. And minors' confidentiality is key for accessing substance use disorder and mental health treatment. In this slide, there is a QR code. It's not the one that it's not for your evaluations, but this is our privacy resources for CHAMP. We have a new edition of our confidentiality book coming out soon. And you can subscribe for updates on new privacy resources or any questions that you have about privacy, but our LEC website has a lot of privacy information on it. And I also wanted to include this. We do have resources for SUD treatment programs responding to immigration enforcement. It's a guide that discusses different legal and privacy protections that patients have when they go to SUD treatment programs and some harm reduction programs. We have this on our website if you wanted to take a look at this and reach out if you had any questions. And that's our LEC slide. So that's all.
Thank you so much. The QR